Saw an interesting personal injury action being reported there last week or the week before on the newspapers, in the media. It was on the RTE News as well. It was to do with a spectator at an amateur golf event in County Sligo, Ross's Point I think it was. Yeah, Ross's Point 5 years ago, County Sligo Golf Club. The spectator was hit on the head by a golf ball, and he brought a claim, personal injury claim, against the golfer in question, the amateur golfer in question, and the golf course, and the GUI and so on. And basically the claimant, Mr. Colm Campbell from County Donegal, claimed that he was in constant pain and his life had been totally changed since he was struck on the left side of his forehead during the West of Ireland Championship for amateur golfers held at County Sligo Golf Club 5 years ago. He sued, as I say, the amateur golfer, and he sued the GUI and County Sligo Golf Club, and he lost his case, and the case went on for 5 or 6 days, 6 days in the High Court. The case went on for, and he's facing a substantial legal costs bill because costs were awarded against him as well. But his fundamental argument was that the golfer and obviously the other defendants were liable in negligence to him. However, the judge didn't find that was the case, and that there was, to a great extent, a responsibility on spectators at golf events to self-police and self-regulate and so on. And all spectators are deemed to have been knowledgeable of the game of golf and would be reasonably expected to take care of their own safety accordingly. Now, his legal team, and obviously he, through his agents, made the case that the golfer in question had hit an errant shot and should have shouted four, when in fact the defence said he didn't hit an errant shot, there was no need to shout four, he was perfectly happy with the shot, and in fact it struck Mr. Campbell, who had not been paying attention, who had been speaking with some of his friends and basically wasn't paying attention. But the argument was that he should have shouted four, and the defence was that he shouldn't have shouted four. There was no need to, because it wasn't a stray or errant shot. And the judge was very impressed with the evidence of the amateur golfer in question, Kevin LeBlanc, and his success, or his defence rather, of the claim was successful. And Mr. Campbell's evidence, essentially, the judge said that Mr. Campbell had not been paying attention at all when the incident occurred. The judge said he was not looking at play, he described people looking for a ball, and that he was talking to his friends. The situation on the ground of this championship was that to a great extent they were self-regulating and self-policing spectators. There's a fundamental, very important lesson though here for anybody who is involved in a personal injury claim or thinking about bringing a personal injury claim. That is, it's not sufficient that you have suffered an injury. You must be able to show that somebody caused your injury and that somebody's negligence caused your injury. And in this situation, Mr. Campbell from Donegal was seeking to hold the golfer liable, the GUI liable, that's the Golf Union of Ireland, liable, and the organisers, or the golf course, County Sligo Golf Course, liable. And basically, in order to establish negligence, you must show certain things. For example, that there's a duty of care, that you have failed to discharge that duty of care, that there's causation between the injury and the act in question that you claim was negligent, and so on. And in this case, Mr. Campbell had failed to prove his case and lost, and 6 days in the High Court is a serious legal bill. Mr. Campbell is from County Donegal, he's a 65-year-old man. He says his life has been changed as a consequence of getting struck on the left side of his forehead, but he's facing a fairly stiff legal bill now. But as I say, just from the point of view of personal injury claims, you must prove that somebody was negligent, and that negligence caused your injury. It's not enough to say that you've suffered an injury, because you could suffer an injury and it could be a simple accident, or it could be one which you were a great contributor to yourself. by your failure to take reasonable care in certain circumstances and so on. And that apparently is what the judge in this particular High Court action found. Anyway, I hope you find the video useful. If you do, I'd appreciate it if you gave it the thumbs up down below. Thanks a lot.